Hi there, how are you doing? In this video, we are basically going to be looking at the legislative process. We are going to look at the steps and the process that a bill passes through before it actually becomes an act of parliament. Ladies and gentlemen, my name is Matiaba Conrad. I'm a lawyer and a private law tutor. Feel free to always contact us in case you need those private tutorial sessions, or in case you need mentorship, or you feel you need an arrangement to be held personally. And these private tutorial sessions have been proven to work, and students who always get into our private tutorial sessions have been proven to outperform their fellow students who actually do not have any form of mentorship. So in today's class, ladies and gentlemen, we're basically going to be looking at the steps followed when legislation is proposed. What are those steps, okay, that are followed when a legislation is proposed? We're going to shortly be looking at that, but also secondly, we're going to look at submission of a bill to cabinet, the process that is actually followed. And then thirdly, we are also going to look at introduction of a bill to parliament. How is a bill introduced to parliament? And then also we are going to look at the assent of a bill by the president and prior processes. So before the moment a bill is passed, there are certain processes that follow, such as publication, among others, and also the assent by the president. And then also lastly, we are going to be looking at the modes, or the ways how bills are actually commenced. And important to note that there are three ways by which actually bills are commenced. And the first way is what we call government by way of government departments or the ministry. So a bill can be commenced by a government department or a certain ministry under the government. And then also secondly, it can be commenced by way of private member's bill, and this is normally commenced by a member of parliament. And then thirdly, we'll also look at bills introduced by committees, which is also another mode. Also important to note, before we commence on the legislative processes, are the laws applicable. This whole process that we're going to look at is generally governed by certain laws. And just to bring you up to speed, it's important that we lay down these laws so that you're in the know and you're able to follow this discussion. The first supreme law, of course, is the Constitution of the Republic of Uganda, or the Constitution of your country, wherever country you come from. And then also secondly is the Acts of Parliaments Act, that is Cap 2. It also has certain principles, legal principles that actually govern the lawmaking process. Then number 3 is the Uganda Public Service Standing Orders of 2010. This is also of essence in the legislative process. And then number 4 is the Budget Act of 2001. It is also authoritative in the process. And then lastly, the Rules of Procedure of Parliament of 2012 are also very authoritative in the same. So having laid down that legal framework which governs the lawmaking process, let's then now proceed to look at the process itself. But however, before we start, ladies and gentlemen, I encourage you to subscribe to my channel. Ensure that you just click on the red button in the lower corner of your screen. Just click on it, subscribe to my channel. Also like and share this video with your colleagues. It's very important so that they also benefit. And then when you subscribe, it will also let you be in the know whenever videos on this channel are released. So let's jump straight into the legislative process. And basically, we are going to start by looking at the steps followed when legislation is proposed. So how does an act, or rather how does a bill, how is a bill initiated? How does it commence? How does it start? This is basically what we are going to be looking at before we proceed to look at the submission of the bill to cabinet. And please note, all these steps actually form the legislative process. Okay, so when we talk of the legislative process, we mean all these different aspects that we are actually going to be looking at very shortly. Now, by way of introduction, it's very important for you to know that actually the legislative process is a constitutional mandate. It's provided for by the 1995 Constitution of the Republic of Uganda, or the Constitution of your country, wherever you come from. Now, specifically for Uganda, Article 79, Clause 1 of the 1995 Constitution actually gives the Parliament of Uganda the mandate to make laws. Okay, so it is the Parliament of Uganda that has the powers and the mandate to make these laws, and not any other organ save for subsidiary legislation, as we'll look at in another class. But for today, we are concentrating on the process of how acts actually become acts, or how bills later on become acts of parliament. So having known the law that actually allows parliament to make laws, let's now proceed into the steps. Now, there has always been this thinking, or this misunderstanding, that actually it is the members of parliament that sit down in the parliament and then they write the acts and the bills. This is actually not the position, and as we are going to see, the legislative process is actually a little bit more complex than you actually thought, and it is a little bit more detailed, and there are so many players that are involved, and we are briefly going to look at it. So the first step basically is the ministry concerned, okay? Remember we said that the modes of commencement, or the modes of how a bill is commenced, are divided into three. So now here we are looking at the first mode, which is by way of a government, ministry, or department. So if a bill is commenced by this way, the first step is that the ministry concerned, Minister of Justice, Minister of Agriculture, whatever ministry of tourism, etc., can, or rather will, approach the cabinet. Okay, and how is this approach made? The approach is by way of cabinet memorandum with a proposal for cabinet to approve the principles for the drafting of the bill. Okay, so the relevant ministry approaches the cabinet by way of cabinet memorandum. That's a document, and their proposals basically would be that we have a certain law, or we have a certain bill that we are trying to initiate or start. This is really very important to note as a first step. Now, cabinet approval in principle here is required before drafting of the subject legislation. So there has to be approval of the cabinet, and authority for this position can be found under paragraph 2 of section 2, paragraph 2 of section QB of the Uganda Public Service Standing Orders of 2010. Those are provide for that requirement. The second step is actually under paragraph 2B of section QB. This section actually provides an exception, okay, and it permits a bill to be drafted by the first parliamentary council if the Attorney General or Solicitor General authorizes the drafting of the bill without reference to cabinet. According to that paragraph, this authority should be granted only and strictly only in special circumstances. The request for the authority should be made through the responsible minister. So as we have stated, that actually a bill will commence by way of cabinet memorandum, and which is put before the cabinet. But we have also went on to say that there is an exception. There are circumstances where actually a bill may not be commenced by cabinet memorandum, okay, or through approval of the cabinet. And here, actually it can be commenced by the first parliamentary council, okay, if the Attorney General, Solicitor General authorizes the drafting of the bill, okay. This is very important to note. The first parliamentary council. Now, cabinet, the third step is that cabinet then considers the proposals as contained in the cabinet memorandum of the ministry concerned, and approves the principles on the basis of the bill, or on the basis of which a bill is to be drafted. Number 4, when cabinet approves those principles for the drafting of a bill, it authorizes the responsible minister to issue drafting instructions to the first parliamentary council or the Attorney General to draft the necessary legislation. Number 5, the ministry concerned would then request the first parliamentary council through the Attorney General to draft the legislation on the basis of the approved principles as contained in the cabinet minute. So there is a cabinet minute. If the cabinet gives a go-ahead, then it is on the basis of that cabinet minute, the minute that the ministry then requests the first parliamentary council through, of course, the Attorney General to go on and draft the legislation. Now, it's important to note that basically the first parliamentary council is a committee, or it's a team of lawyers who are actually experienced in legislative drafting, who actually sit down and draft most, or actually all, the laws that you see today. Okay, choose any law, Contracts Act, the Penal Code. Most of those laws are actually drafted by the first parliamentary council. Next step is where the instructions are not clear, because there are circumstances where the instructions are not clear. If those instructions are not clear, the first parliamentary council will ask the ministry concerned for further instructions, and where necessary request the ministry to identify an officer in the ministry, okay? Because remember, it's the ministry that commenced the bill. So it can request an officer in the ministry to actually liaise with the office of the first parliamentary council in the drafting of the bill, okay? This is also important to note. Step number 7 to note is that in drafting of the legislation, the office of the first parliamentary council will interact with the ministry concerned to arrive at an agreed draft. So they will keep on liaising and discussing to ensure that actually they come to a consensus on the first draft, as the ministry would actually want the law to appear for the purpose of it becoming an act. Step number 8 is that the ministry concerned may again consult stakeholders as to the contents of the bill. So consultation in the legislative process is actually provided for, okay, and they can go on to consult as to the contents of the bill. And of course, due to that consultation, necessary modifications, inclusions, or even omissions can be added at that stage. Step number 9, the ministry concerned will have to submit the bill to cabinet for approval together with a cabinet memorandum. These are actually submitted together because it's a cabinet memorandum that shows the initiation or the commencement of the bill. And any comments of the stakeholders, if there are any comments from the public, as we have earlier looked at, they will also be included. When you look at paragraph 7 of section Q to B of the Uganda Public Service Standing Orders of 2010, it actually provides that no bill, okay, without exception should be published unless it has been submitted to cabinet for approval. So cabinet approval is very, very paramount in the circumstances, and the law prohibits the publication of a bill without approval of cabinet. Step number 10, in the course of drafting the bill, okay, the draftsperson is required to bear in mind the need to keep informed the law officers, and namely that is the Attorney General and the Solicitor General. This is regulated by paragraph 6 of section QB. Okay, so you have to keep the Attorney General and the Solicitor General in the know during this whole process. Okay, very important to note. So basically, those are the steps that will be taken. Let's now proceed to look at submission of the bill to cabinet. How does the bill, or how is the bill submitted to cabinet? And all this forms part of the legislative process. Now, when the bill is being submitted to cabinet for approval, the cabinet memorandum of the ministry will have to be accompanied by the following. The following have as a requirement of the law to be accompanied, okay, by the cabinet memorandum. Number 1 is a certificate of compliance. A certificate of compliance is key, and it has to accompany the cabinet memorandum. Of course, a certificate of compliance issued by the office of the first parliamentary council to the effect that the bill has been drafted by the office of the first parliamentary council in accordance with the principles approved in the cabinet decision issued for the drafting of the bill, or that the bill has been drafted on the basis of a waiver of prior cabinet approval in principle by the Attorney General or the Solicitor General under paragraph 2B of section QB of the Uganda Public Service Standing Orders of 2010. Now, when we talk of a certificate of compliance, this has to be issued by the office of the first parliamentary council. That is the committee of lawyers that have actually drafted the bill. The reason why a certificate of compliance is key, it's because it is this certificate of compliance that shows that actually this bill was commenced by way of memoranda, or that if it didn't commence by way of memoranda, then actually this bill was, or rather it commenced with the approval of the Attorney General or the Solicitor General. Because remember, we said that this is an exception, okay, where a bill can actually be commenced by these two offices without actually approval or commencement by way of the cabinet. Now, the other second accompaniment is what we call a certificate of financial implication. A certificate of financial implication is issued by the Minister of Finance in accordance with Section 10 of the Budget Act of 2001. Now, the Budget Act requires that a bill must actually be accompanied by a certificate of financial implication. This certificate of financial implication is basically showing the effect or the cost that is attached to the bill, because you see these bills that actually become law may have a financial implication. There are certain bills that may require enforcement, or that may require maybe government to hire people to enforce such a law, and therefore this brings a financial implication on government. And of course this has an implication on the taxes that are collected. That means that the Uganda Revenue Authority would probably have to increase the tax, or to widen the tax base, so that such an act, okay, or such an be a bill, once it becomes act, is financed, okay, for its efficiency or effectiveness. As such, a certificate of financial implication is very important at this stage, and that certificate of financial implication must state in respect of the bill in question the financial implications, if any, on revenue and expenditure over a period of not less than 2 years after its coming into force. Okay, when you look at Rule 107 sub Rule 2 of the rules, it requires the certificate of financial implication to be signed by the minister responsible for finance. So the minister responsible for finance must actually sign this certificate of financial implication, and the certificate itself must show a projection, a financial projection of the act for the next 2 years after the act has actually come into force. So those two documents, i.e. a certificate of compliance and a certificate of financial implication, must actually accompany the cabinet memorandum, okay, when the bill is being submitted to cabinet. This is important to note. Next is that cabinet may approve or reject the bill. Now, the moment the bill is sent to cabinet, it's not mandatory that the cabinet has to accept. Okay, it may approve it, or it may reject the bill, or may approve the bill subject to amendments. The cabinet may say, okay, we have seen the bill, but first make these amendments to these sections in the bill. Next, the office of the first parliamentary council will then incorporate any amendments approved by cabinet in the bill and seek the signature of the minister concerned to an explanatory memorandum attached to the bill. So of course, if cabinet makes those amendments, then these have to be incorporated into the bill. Next is when you look under Rule 106 sub Rule 2 of the rules, they actually require that all bills shall be accompanied by an explanatory memorandum setting out the policy and principles of the bill, the defects in the existing law, if any, the remedies proposed to deal with those defects, and the necessity for introduction of the bill. According to Rule 106 sub Rule 3, okay, of those rules, when you look at them, it actually provides that an explanatory memorandum shall be signed by the minister or by a member introducing the bill. Okay, that is in the case of a private member's bill. So this is also important to note. Next is the first parliamentary council will authorize the government printer. So it is the first parliamentary council that actually authorizes the government printer. The Uganda Printing and Publishing Corporation, also abbreviated as UPPC, to print and publish the bill in the Uganda Gazette. So after the bill has been approved by cabinet, all the necessary amendments have been made. It is then the first parliamentary council that actually authorizes the printing of the bill and also for it to be published in the Uganda Gazette. The next step is the ministry concerned must issue a local purchase order, also known as the LPO, to be issued in favor of the government printer, who we abbreviated as UPPC, to cover the costs of printing and publishing of the bill. This is based on an estimate of costs issued by the government printer. After that, when you look at Rule 106 sub Rule 1 of the Rules of Procedure of Parliament, it actually provides that all bills shall be published in the Gazette. So the position of the law is that the publication of bills is mandatory according to the law. After publication in the Gazette, the ministry concerned will have to supply about 529 copies of the bill to the clerk, to Parliament, for use of parliamentarians. Because today, I think we have about 529, okay, members of Parliament. So you have to publish all the relevant copies that fit the numbers of members of Parliament have to be, of course, printed. The next step is the ministry concerned will also have to supply to Parliament the certificate of financial implication to be tabled in Parliament for the first reading of the bill. This is also important to note. Now, after that, we are now proceeding to look at the introduction of the bill to Parliament. Now, the bill is finally now introduced to Parliament. The other preliminaries have been done. Okay, the gazetting, the publication, printing copies of the bill. It is now finally, it now goes to the third stage. Is now here our bill now is introduced to the Parliament. Now, when the bill is introduced to Parliament, a number of things happen, and these include the following. Of course, the bill then goes through the process of parliamentary of Parliament necessary for passing the bill. When you look at Rule 114 of the rules, it provides that every bill shall be read 3 times prior to its being passed. Very important. Before a bill is actually passed into law, it has to be read 3 times, and this is a requirement of the law. The processes are prescribed or provided for by the rules, and that is from Part 18 to 21, and they include the following. The first step is what we call the first reading. The bill now, our bill now, when it comes before Parliament, it goes for the first reading. Now, this first reading is more of a formality. It marks the formal introduction of the bill in Parliament, and the bill is then committed to the relevant sessional committee of Parliament for consideration. At this stage, the committee will normally invite the relevant minister to introduce the bill. So the minister comes and then introduces the bill. And he may invite other stakeholders to actually state their views on the provisions of the bill. And the committee may even sometimes hold hearings for the purpose. You remember when our bill was being made, views may have been sought, okay, as to the input of certain stakeholders on the bill. So these stakeholders can actually be invited to come and actually give their views or their proposals as to the same. So this is done during the first reading. The second step is what we call the submission of the report by the sessional committee. Now, this sessional committee now proceeds to actually submit a report. The committee, which committee? The session committee, must submit a report on the bill to the plenary of Parliament. And at the same time, Parliament will consider the bill at the second reading, which is a debate on the principles and policies of the bill and not on its details. Now, during the submission of the report by the sessional committee, here the debate now happens. And the Parliament basically starts to debate on the principles and the policies of the bill and not on its details, because every bill has principles and policies on which it is actually based. So these will be debated at this level and not the details. Here they will not go into the details of the sections and so on, the clauses. No. They will only look at the principles and the policies, and the debate on the same will be done, because it is the principles and policies that actually inform the contents of the bill. According to Rule 119, Sub-Rule 5 of the rules, the second reading of the bill shall not be taken earlier than the 14th day after publication of the bill in the Gazette, unless, of course, the sub-rule is formally suspended for that purpose. The next step, of course, is the Committee of the Whole House stage. Okay? Now the bill goes to the Committee of the Whole House stage. This is the stage of the bill at which Parliament deals with the provisions of the bill. Now here, Parliament will now proceed to look at the details of the bill, the clauses therein, clause by clause, and all proposed amendments to the bill. Okay, here there will be complete scrutiny, a step-by-step analysis of these clauses. The committee stage is regulated by Part 20 of the rules. You look at Rule 120 to Rule 124 of the rules. It provides for all the formalities at this stage where the bill comes before the committee of the whole of the whole house stage. Next is that at committee stage, the speaker sits in the house as a chairperson of the committee of the whole house. Considering amendments to the bill, authority for that position, look at Rule 122 sub Rule 1. It is authoritative on the same. Next, according to Rule 123 sub Rule 4 of the Rules of Procedure of Parliament, the committee of the whole house shall consider proposed amendments by the committee to which the bill was referred, and may consider proposed amendments on notice where the amendments were presented but rejected by the relevant committee, or where, for reasonable cause, the amendments were not presented before the relevant committee. So all this now will be considered at that stage. The next step is the report of committee after committee stage. Now, this is where the committee of the whole house reports to the plenary on the bill, which has been committed and amendments are considered. That's according to Rule 125. The next step is what we call recommittal. This is a stage which comes at the end of the committee stage, where it is felt that there are or there is still certain amendments which have to be considered or reconsidered. That is according to Part 21, and specifically look at Rule 127. The other step is what we call the third reading and the passing of the bill. Finally, now here, our bill is read and then passed. At this stage, the bill is not debated. Here, there is no debate because most of the debate has been done in the other prior stages. The corrections, the amendments, everything has been done. So at the third reading and at the passing of the bill stage, here, there is no debate, okay? And it is passed as a formality upon a motion. You normally hear members of parliament saying that the bill be now read the third time and do pass. You normally hear that. So normally this is the third reading and the passing of the bill stage, okay? And here, the bill is now passed. And of course, after this stage, the moment the bill here is passed, it is, of course, sent to the president so that the president can also have a look at it for purposes of assent. Okay, we are going to look at that stage where now the bill moves from parliament to go to the president. But before we go there, I wanted us to look at the publication of the acts. Okay, now, when you look at section 8 to 13 of the Acts of Parliaments Act Cap 2, it regulates the preparation of presentation copies. Okay, they are sent by the president. It is actually that act that provides for the president to assent to the law. And we'll also be looking at the constitution. There is actually an article, I think it should be Article 91, Clause 1. We'll be looking at it in material detail to see that other stage where the bill now moves from parliament to go to the president for assent. But basically, when you look at section 8 to 13 of the Acts of Parliaments Act, it provides for the regulation of the preparation of presentation copies. They are sent by the president, presentation of a bill for assent under Article 91, Clause 1, the numbering of acts, original copies of acts assented to by the president, or becoming law without the assent of the president, and the publication of the acts in the Gazette. So all those, okay, how does the act, the publication in the Gazette, the assent, what happens when it is rejected? Please look at the Acts of Parliaments Act Cap 2. But we are going to interrogate a little bit more Article 91. Article 91 of the Constitution, okay, which actually provides for the processes of actually what happens when the bill is actually sent to the president. Now, let's proceed, and here please just buckle up and hold on a little bit more patiently. Now, the moment the parliament passes the bill, because remember here it has not yet become an act, it only becomes an act after it's assented to by the president or passed by the parliament when the president refuses to assent to it. So our bill, after it has been now passed by parliament, it is now sent to the president for assent or approval. Now, when it goes to the president for assent or approval, when you look at Article 91, Clause 1 of the 1995 Constitution of the Republic of Uganda, it actually provides for a number of scenarios that may happen. Because you see, when you send this bill to the president, it is not mandatory that he has to assent to it. Now, the Constitution has provided for what may be the outcome. One, the president may assent to it. That is scenario number one. If the president assents to it, then the bill will become law. But the president may actually not assent to it per se, but the president may actually request under, when you look under Article 91, Clause 3, okay? The president may not assent to it, but the president may request that actually the bill be sent back to Parliament for the modification, okay, or certain changes to certain clauses of the bill. That is the second scenario. But also the third scenario is that the president may actually refuse to assent to that bill. Now, the Constitution foresaw all these, and they are provided for under the law. If the president assents to it, it becomes law. If the president, however, under Article 91, Clause 3, I think it should be Part B, sends it back to Parliament, maybe for certain amendments to be made, or certain modifications, certain additions, or omissions, or whatever, then the Parliament or the members of Parliament will sit again and consider those amendments and then send it back for the president to assent to it. If the president puts his signature on it, it becomes law. But if the president refuses, okay, for the second time to actually assent to it and makes more recommendations, it will go back to the Parliament for those recommendations to be put in place. Okay, and if the recommendations are put in place and it is sent back to him and he refuses to assent to it, then such a bill will automatically actually become law without the assent of the president. Very important to note. Okay, and then in the situation or in the event that actually the president just refuses, he may also refuse without any reason or with reasons, but he refuses to assent to it. Such a bill will go back to Parliament so that actually it is reconsidered. Okay, so basically that is what happens when the bill is sent to Parliament, rather to the president for purposes of assent. And it is also important to note that when this bill is sent to the president, there are actually timelines within which the president has to assent to the same. And when you look under Article 91, Clause 3, it actually provides that the president has to give a reply, okay, within 30 days. So he has 30 days, which is about a month, to give a reply, either to assent or to send it back to Parliament for the necessary modifications or to actually refuse. So the Constitution gives timelines within which the president must basically act. So basically, that then brings our legislative process to an end when the president has assented to it, or where the president refuses after 2 to 3 times, and then of course the act becomes law, okay, with or without the assent of president, and a bill can still become a law in Uganda. Let's now proceed. Okay, remember we have now been looking at the mode where the bill has actually been commenced by way of cabinet memorandum, or it has been initiated by way of a government ministry or department. But remember, we also said that there is a second mode. And which mode is that? The private members bill. Okay, so a law can actually be commenced by way of private members bill. A private members bill here, basically what we mean is that a member of parliament on his or her own motion can actually commence a bill, okay, or an act of parliament. And this is regulated by the Constitution. I encourage you to look at Article 94, Clause 4 of the Constitution. It provides for the same. And what you have to note under this article, under Article 94, Clause 4, it provides for the rules and the procedure of Parliament, okay, where a bill is actually commenced by way of private members. And it provides under Part B that a member of Parliament has the right to move a private member's bill. Okay, that's one. C, the member moving the private member's bill shall be afforded reasonable assistance by the department of government whose area of operation is affected by the bill. So if the bill, for example, is about, let's say, the judiciary, then of course that will fall under the Ministry of Justice and Constitutional Affairs. So that Ministry of Justice and Constitutional Affairs has to assist this private member or this member of parliament who is commencing the bill on his own motion, it has to help him in the drafting of such a bill. Then also Part D of the Constitution, it actually provides that the office of the Attorney General shall afford the member moving the private member's bill professional assistance in the drafting of the bill. Now, this is important because as you have seen the legislative making process, it's very technical and it requires a lot of expertise. You need to have deep legal knowledge. And I think as until today, you have actually realized that this process is more complex than you actually thought, or you initially thought that it's narrow, but it's very complex and very technical. So that ministry or department under which the bill actually falls must go on to give this technical assistance to this member of parliament so that a proper bill is actually drafted. Now, following the provisions of the Constitution and also Rule 110, it provides for the private member's bill, and specifically Rule 111 of the rules provides for the following procedure in respect of a private member's bill. Rule 111, Sub-Rule 1, it provides that a private member's bill shall be introduced first by way of motion, to which shall be attached the proposed draft of the bill. So if it's a private member's bill, it is introduced by way of motion, and there must be an attachment of the draft of the bill. So our member of parliament, who has proceeded by way of private member's bill, has to go on and make a draft of the bill. How would they want their act to look like? Then, when you look at Rule 111, Sub-Rule 2, it provides that if the motion is carried, the printing and publication of the bill in the Gazette shall be a responsibility of the clerk. So the clerk then goes on to make the publication and the printing of the bill, okay? And of course, the publication is in the Gazette. Why is this important? So that the public can actually get to know about the bill and the general public is in the know. Then number 3, following the publication of the bill in the Gazette, the process of the bill shall be the same as that followed in the respect of a government bill. So from there, after the publication of the bill in the Gazette, the process that follows is what I actually discussed for you and what we looked at earlier. It then follows, okay? It's brought before Parliament, it's debated, all those steps that we looked at earlier is what this private member's bill will actually follow from this stage. So basically, that's how the private member's bill will be commenced, and that is the process that the private member's bill also actually follows. Now, important to note here are certain provisions that are not applicable to private members' bill. So if a bill is commenced by way of private members, there are certain provisions that are not applicable. Of course, needless to say that a private member's bill, not being a government bill, of course, will not require cabinet approval. Okay, so a private member's bill does not require cabinet approval, as we looked at earlier, under a bill that has been initiated by a government department or ministry. It, however, requires, even if it doesn't require cabinet approval, this private member's bill, however, requires a certificate of financial implication. You remember we looked at it from the Ministry of Finance, Planning and Economic Development, just as does a government bill. So it requires, again, a certificate of financial implication. It's very important because it has a monetary or pecuniary implications on government. Then also, it will also not require a certificate of compliance issued by the office of the first parliamentary council. Of course, because it was not commenced by the first parliamentary council, so it doesn't require that certificate of compliance, okay, by the first parliamentary council. Otherwise, the procedure for processing a private member's bill is the same as that of a government bill. It is the same, save for those first steps that I have just discussed for you. Then let's now proceed to look at the third mode of bills, because remember we have said that bills can be commenced by way of a government, ministry or department. Then we have also said that bills can actually be commenced by way of private member's bill by an independent member of parliament. Now we are going to look at bills that are the third mode of how bills can actually be commenced, and this is what we call bills introduced by committees. So committees can also introduce certain bills, and that is under Rule 147. Okay, when you go and read under that rule, it expressly provides for the same. And here, a committee of the House may initiate any bill within its area of competence and shall be introduced by the chairperson of the committee in the same manner as a private member's bill. Authority for that position, I encourage you to look at Rule 112 and Rule 147B. It provides for bills that can actually be commenced by way of committees or by these committees in Parliament. So basically, ladies and gentlemen, that is the legislative process, and that is how the process actually moves. Once again, I encourage you, in case you're interested in private tutorial sessions with the experts, in case you're interested in mentorship, please feel free to contact us directly. Our number is down in the description box. You can contact us, and we can always make arrangement for these private tutorial sessions. These private tutorial sessions actually work. You need mentorship, you need an expert to help you. Please ensure that you contact us. And students normally on our private tutorial sessions have been proven to outperform their fellows while in law school. Thank you very much. Do not forget to subscribe, to like, and share this channel. We meet again in another class. May the Lord God bless you. Bye-bye.